Okay, so we are calling to order the Corrections Policy Committee meeting today. Today's August 12th, 2025, and it's 10 a.m. and we're at the DPSST building in Salem. We need to do the public meeting statement announcement. So this is a public meeting subject to public meeting law and will be recorded. Deliberation of issues will only be conducted by Corrections Policy Committee members unless permitted by the chair. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence proves a safety risk to the other persons in the room and makes it impossible to continue the meeting. Okay, so we'll do introductions.
And I can go ahead and start this off.
Yes,
We'll begin with you, Chair Cameron.
Okay,
All you have to do is state your name and who you represent for your position.
Yes, Jennifer Cameron, and I represent non-management probation.
Member Aldridge.
Josh Aldridge, Jackson County Sheriff's Office, representing the Jail Command Council.
Member Bourne.
Mark Bourne, public member.
Member Bowden.
Margo Bowden, non-management corrections.
Member Frasco.
Lori Frasco, Department of Corrections, AFSCME.
And then online we have Member Frost.
Non-management corrections for AFSCME at Snake River.
Thank you. Member Hartford.
Mike Hartford, representing the Oregon Association of Community Corrections Directors.
Member Hunter.
Nick Hunter, representing the Oregon State Sheriff's Association.
Member Langley.
Ted Langley, Lane County Sheriff's Office, representing Jail Command Council.
And then online we have Member Mays. Member Mays, can you hear us? Let's come back to Member Tabor.
John Tabor, Professional Development Unit Administrator for the Department of Corrections.
Member Mays, are you back? For staff introductions, Juan Lopez, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, CPSST.
Jennifer Lavario, Professional Standards Compliance Coordinator, DPSST.
Kathleen Calpine, DPSST.
Marie Atwood, Professional Standards Division Director, DPSST.
It only makes
I'll work on it. I'll work on it.
Melissa Langacho, DPSST.
And then online. If you can hear us.
Yeah.
Is that to me?
Can you hear me? Is that a yes or no?
Yes, we can hear you.
Okay. Okay, there we go. Justin White.
Director Castle.
Yep, Phil Castle, DPSST.
Thank you so much. And I believe we also have Bree Murphy online.
Bree Murphy, DPSST.
Thank you. Back to you, Chair Cameron.
Okay, do we need to introduce the people in the back?
Oh, the rest of the group.
Park, DPSST. Howell, DPSST.
Hamilton, criminal justice compliance, criminal justice certification.
Thank you, DPSST.
Hey, good morning, everybody. Welcome. The first item up will be the approving the May 13th, 2025 minutes. Has everybody had a chance to review them? Online, yes. Were there any requested modifications? If not, we'll look to confirm consensus and approve the meeting minutes. Hearing none, does everybody approve the minutes? Shake your heads. Yes, yes. So it looks like we have a consensus of the meeting minutes from May 13th are approved. Next, we'll head into administrative closures. We'll turn it over to, I believe, you, Jennifer, to take charge on that.
Thank you, Vice Chair Cameron. Committee Jennifer Lavario for the record. We did prepare 4 administrative closures for the committee today, which are to be ratified by 1 vote. The department may recommend administrative closure of discretionary professional standards cases to the committee when we determine that the conduct being reviewed does not meet the statutory and administrative rule requirements for denial of revocation. Vice Chair.
Are there any questions or discussions regarding the administrative closures that anybody has? Online? No questions? Okay. And any other recommendations with that? None? Okay. Then we will call for a motion to approve the consent agenda as presented, or as modified. Do you call that?
I could do the motion.
Oh, we have to do the motion. See, this is my first time chairing this meeting. I get
For the
there.
record, so moved.
Josh Eldridge, I'll second.
Okay, so we have a motion to approve the consent agenda.
Right, we are voting on a motion to approve the administrative closures. Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bode.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langman.
Aye.
Committee Member Mays. Committee Member Tabor. Thank you. Committee Member Tabor.
Aye.
Motion passed.
Okay, next, we're gonna move into the professional standards case reviews. We have, 1 in-person, testimony, which is, Ms. Padilla, and then a virtual, which will be number 4. No, never mind. We're not gonna, hear the case against Bonnie Kessel. So that one we can take off. Then we have the in-person, which is, Ms. Padilla, that's, item number 7, and then number 11 is a virtual, which is Justin White. So we're gonna skip to 7 and then go to 11, on the agenda.
Chair, can I ask a quick question?
You
on
absolutely
Bonnie Kessel,
can.
why that one was removed? Because we moved that one from the last one to this one.
And I cannot answer that, so I'm sure somebody that knows will.
Maria, for the record, I can answer that question. We inadvertently gave Ms. Kessel the incorrect date. So rather than assume she would be here and not give her the opportunity to be heard, we're just gonna bump her to the next session.
Thank you.
Okay, so go ahead, Jennifer.
I believe Juan may be out getting Ms. Padilla because she's here with it.
So we'll, have her come in and go from there.
Yeah.
Certainly very, yes, that's, and that includes.
Good morning, Ms. Padilla. Thank you for coming in today. You'll have 5 minutes to explain your mitigating rules or mitigating statements, and Jennifer Lavario will explain the rest from here.
Thank you, Chair. Ms. Padilla, we talked in the outside for a moment about what's going to happen. What I'm going to do is present the case and then you'll be given your 5 minutes. Okay. Jennifer Lavario for the record. This case is about Hurlit Padilla. The department opened a professional standards review after receiving information that Hurlit Padilla was charged with driving under the influence of intoxicants and reckless driving on February 9th of 2024 in Clatsop County. On January 24th of 2025, Ms. Padilla entered a plea of no contest and was convicted of DUI and sentenced to 18 months of bench probation, to include a driver's license suspension until January of 2026. Ms. Padilla is currently employed by the Clatsop County Sheriff's Office. The department's review determined Ms. Padilla did violate course moral fitness standards for misconduct. Ms. Padilla engaged in misconduct when she violated criminal law, pled no contest to, and was convicted of driving under the influence of intoxicants. Ms. Padilla engaged in misconduct when she drove her vehicle while under the influence of alcohol, which threatened harm to others and property. Ms. Padilla engaged in misconduct when she harmed the efficient operations of the Clatsop County Sheriff's Office by engaging in criminal conduct in the jurisdiction in which she worked, which violated the Criminal Justice Code of Ethics, the public's trust, and the integrity of the Sheriff's Office, led to a last chance agreement to prevent any future harm. Ms. Padilla, are you prepared to provide your statement?
Yes.
Just a word of caution that we won't be having any questions or answers during the 5-minute period. And I may give you a 1-minute warning if we get to that point.
Okay.
Okay. Whenever you're ready.
Okay. So I was just going to start by reading a letter from Warriors Heart, which is a inpatient facility in Banderas, Texas. I was not able to attach it to the previous email submitted before July 7th. Says Hurlett was admitted to Warriors Heart on March 24th, 2024 to complete the residential inpatient treatment program and was successfully discharged on May 8th, 2024. Warriors Heart is a private treatment facility for first responders, veterans, military, and law enforcement officers. Our team provides our clients with the best treatment in the field as we specialize in private, confidential substance, alcohol abuse, addiction, and co-occurring psychological and moral injury. Each client is assessed for both mental and health and medical conditions and given their own customized treatment plan. The course includes the 12-step program CBT, which is cognitive behavioral therapy, cognitive restructuring, trauma treatment such as EMDR, which is eye movement desensitization and reprocessing, chronic pain management, harm reduction, examination of triggers, anger management, relapse prevention, aftercare, narrative therapy, nature hikes, life skills and resilience building, family couple counseling, canine art therapy, and the middle shop blacksmith. They're located at 543 Acre Ranch in Banderas, Texas, which was carefully selected because it provides serenity, space, and still within the cities and amenities. Our model at Warriors Heart is to allow healing in a home-like environment, healing while uncomfortable at times, but recovery should also feel good. Warriors Heart creates a space that looks and feels comfortable and fosters the healing process. During her stay at Warriors Heart, she participated in elective programming to include woodshop, jiu-jitsu, and training in the service canine she adopted, she took home. For at least 1 week in each capacity, Hurlett also received the Warrior Community as LS campus team lead and canine lead during her stay. And Hurlett completed all clinical assignments and met all benchmarks for successful completion of the program. I just wanted to read it out loud to show some of the programs there. And I did. I did enter Warriors Heart actually right the same day as the incident that was put on administrative leave. I did call Warriors Heart and registered for the program. Some of the obstacles, hurdles since the incident have been the legal case, which has been very challenging because it's public and having to explain that to my children as well was challenging. And being in the public, especially with the social media platforms available that became, available and was actually very, I don't even know the word for it, being scrutinized by the public for what I've done, which was like being a disappointment all over again. But that's something that I have tried overcoming because there is still a webpage or social media page that completely has it still posted up there. It has my face, it has my pictures, it has all my legal information on there. And just having some of that criticism from the public, it was really rough. But I was more worried about how it's affected my children as well as my employer, having been brought up again. But just knowing that my children were actually proud of me, wanted to stand up for me because I've known what I've gone through and how I started, what it was like for me drinking, and how I'm now having that sobriety now.
1 minute.
Left. Okay. I have also like obstacles like friends passing away, my son being in a car accident here in June and in July, my dad being diagnosed with cancer, like those are things that I normally would have put me into an environment where I feel like I would have had to drink just to be numb and forget some of those things going on. But I haven't, and that's huge because that was my go-to. That's my comfort. So I feel like I have improved. I have done things to do better. Currently doing my community service hours at an entity that helps the homeless, but also want to continue to do that even after my community service hours because it helps more of the vulnerable people and those that have also their own substance abuse problems, and just being able to build that rapport with them makes a difference. So I'm just cheering on you.
Thank you, for the information. Now we're gonna move forward and ask for consensus of the committee to adopt the record, regarding, Ms. Padilla's case. Or return it for any other information. We have to make a motion for that, I do believe. No, which is a consensus, that's right. Okay, so that's just any objections to moving it forward at all? Okay, so we have a consensus for that. So we've adopted the record. So we're I'm walking through this the first time, so bear with me. So now we'll open it up for a discussion of aggravating or mitigating factors. So please state your name and identify your aggravating or mitigating factors in this case.
Nick Gunner for the record, aggravating factor is the previous DUI. The previous DUI was before employment with the Clatsop County Sheriff's Office, but that does exist as another criminal charge where potentially the public was put into harm by actions of Ms. Padilla. On the mitigating side, mitigating factor is Ms. Padilla being here today, accepting responsibility and providing mitigation. And it's also a mitigating factor that Sheriff Phillips is in the room in support of Ms. Padilla.
Thank you.
Ted Langley for the record. One of the circumstances that I thought was aggravating was the fact that while her training record is not extremely long, just because of her time in service, there is ethics training on there, and ethics training is supposed to create a foundation of being ethical and help us learn how to do that. And I feel like in this case, the fact that there was ethics training given and she was maybe still unable to identify that what she did was unethical. On the mitigating side, she was honest with the deputy that pulled her over initially as far as whether or not she had been drinking. And I also found it mitigating that the office was also willing to allow her a last chance offer.
Thank you.
Josh Eldridge for the record, mitigating circumstance. Ms. Padilla sought out treatment and it sounds like has been fairly successful in treatment immediately following. Additional mitigating circumstance, piggybacking on Commander Langley's comment about cooperation, even the arresting officer in his police report mentioned that Ms. Padilla was cooperative, didn't try to use her position in law enforcement to gain any advantage.
Thank you. Anybody online? Not seeing anything. Anybody else have any?
Nick Hunter for the record, mitigating circumstance throughout the what was a fairly extensive internal investigation. It appeared that Ms. Padilla was forthright with information, was cooperative with investigators. It appears to be a fairly tight-knit family where others could have said them something or used influence or other things like that. And it didn't seem like that during the investigation. It seemed like everybody was forthright with information, which really highlighted Ms. Padilla's problem. that she's chosen to address. And I think I would almost, and it's probably an odd in this situation, but second, the mitigating factor that Josh brought up, that quite simply choosing to put yourself into treatment and to actually address the root of the problem.
Thank you. I'd like to add, Jennifer Cameron, for the record, I want to add one mitigating factor, that she stated, when she was going through some hard times, that she went back to her treatment and she made it through those times staying sober, which I think is a positive for her, showing that she's gained some knowledge from her treatment. Anything else from anybody? Want to go ahead and let us know, recall? Sure. All those.
Thank you, Vice Chair Cameron. Jennifer Lavario again, for the record. For aggravating, I have, there was a previous DUI before she was employed with Clatsop County, where the potential for public harm was could have occurred. Her training record, this is also aggravating, indicates that there was ethics training that she would have gone through, which should have helped her learn how to be ethical. But in this case, it seemed as though she was unable to do that. For mitigation, she accepted responsibility for her actions. Sheriff Phillips is here to support her. She was honest with the deputy who pulled her over, and that deputy also mentioned that in his report. The last chance agreement that the agency allowed her to take part in is also mitigating. She did seek out treatment on her own. Throughout the internal investigation, she was forthright and cooperative, as well as the agency was forthright. Everyone there was forthright in that investigation. Choosing treatment to address her root problems was mitigating, and she went through hard times. She also went back to treatment to try to address some of those issues.
Josh Aldridge, for the record, one point of clarity. The deputy who initially pulled Miss Padilla over and the officer who wrote the criminal report are two separate individuals.
Thank you.
Thank you, Jennifer. Excuse me. So we need to have a consensus that we've identified all those factors, that she's got all those, okay. Then we want to open for discussion about whether there was a moral fitness violation. Remember, with her, the allegation is misconduct, which carries a 3 to 10 year ineligibility period. So how do you know that? And do we need to affirm? Is that a vote? Okay, so we need to have a motion to affirm the mitigating and aggravating factors as stated. Is that right?
It's
No?
to affirm, negate, or modify the or fitness violation.
Oh, okay, so that would be the
Then noted the act.
Madam
okay.
Chair, Nick Hunter, for the record, I make a motion that we accept the DPSST staff report,
There we go.
identifying those, between dishonesty, misconduct, third one, which I'm gonna lose my mind right now, misuse of authority, accept that as DPSST prepared it.
Thank you.
Josh Aldridge, I'll second.
Now we can have a vote.
We are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Boring.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so the next step is we need to have a motion.
Madam
Yeah,
Chair,
okay.
Nick Hunter, for the
Yeah,
record,
thank you.
I'll make
I
a
think
motion
through.
that we take no action in this case.
Mark Foran, for the record, I'll second.
Yes. You need to state why you're recommending that.
Oh, thank you. See, good clarification. We're figuring it out. Nick Hunter, for the record, make a motion that we take no action in this case. So we have confirmed or substantiated the moral fitness conduct. I believe that the mitigating factors, the steps that Ms. Padilla has taken since this incident to truly address the SUD portion of it and make those changes to become a more positive influence within not only our own agency, but in the community would be the reasoning for taking no action.
Thank you.
Mark Bourne, for the record, I'll second for the same reason, Sheriff Hunter.
All right, we are voting on a motion to take no action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Pasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Passed.
Thank you, Ms. Padilla.
Thank
for
you.
your time.
Started all over again. That's okay. I'll get it. I'll figure it out. But interesting. That's all good.
You're good.
I'm gonna say Nick's got it.
I know, and I appreciate that. I will have this back too. Okay, next we're gonna go to the virtual testimony with Justin White. Is he on?
Mr. White?
Yeah.
Jennifer, you wanna take over?
Sure. Justin, you have a representative.
If you're talking, you cut out, I can't hear you.
Sorry, just want to identify your representative here today. Have someone with you?
Correct, that would be legal representation, Mr. Peter Drunkenmiller.
Thank you. Okay, so I'll begin with the review of the case. I'll let you know when it's time to provide your verbal mitigation. This case came before the committee last quarter. I believe everyone here may have been on the committee, but I'm not certain at that time. The reason we're back here today is to provide Mr. White the opportunity to give his verbal statement because we gave him the wrong link to do so last time. So the case is, we opened a professional standards review after Justin White was terminated from the Oregon Department of Corrections Two Rivers Correctional Institution on April 10th of 2019. Mr. White was terminated for declining to fulfill an overtime request and received under the influence and reckless driving charge in Washington State on November 10th of 2018. Mr. White grieved his termination and it went to arbitration. The arbitration resulted in the decision by the arbitrator that although Mr. White did engage in misconduct, the Department of Corrections did employ the proper progressive discipline process. Therefore, he was reinstated to employment. While reviewing the separation of Mr. White, the department became aware of a criminal disposition that Mr. White did not report to the department while he was employed at the Department of Corrections. Mr. White was cited for failure to stop, give information, or aid, a misdemeanor on March 12th of 2016. This case was diverted and subsequently dismissed on June 13th of 2017. On November 17th of 2021, Mr. White pled guilty to reckless driving, an amended judgment from the original charges of DUI and reckless driving. On September 3rd, 2022, Mr. White was transferred to the Eastern Oregon Correctional Facility where he is currently employed. The department's review determined that Mr. White did violate the board's moral fitness standards for misconduct. Mr. White violated criminal law while employed as a corrections officer and admitted to driving while under the influence of alcohol. Mr. White's conduct threatened harm to people and property and violated the Criminal Justice Code of Ethics. Violated several laws while in which threatened harm to people and property. The totality of which, along with DUI and reckless driving, evidenced a disregard for the traffic laws of both the state of Oregon and the state of Washington. As a corrections officer, Mr. White was responsible for holding adults accountable for their actions related to rules and laws. Corrections officers are expected to provide an example of behavior that aligns with sound judgment and rule-abiding behavior. Vice Chair Cameron. Oh, I'm sorry. Got ahead of myself. Excuse me for that. Mr. White, are you prepared to statement?
Sorry, you're cutting out. What did you say?
Would you like to provide your statement now? I can start the clock.
Yes, ma'am. But I just want to confirm, we are talking about the reckless, the DUI arrest, the refusal of overtime. And those are the other two, correct?
At this point, we are an opportunity to provide based on the staff report that we presented to the committee.
Right, and you're kind of been cutting out, so can you repeat what the basically what the allegations are, please?
Vice Chair Cameron, would you like me to go over those again so he can hear them?
Yes, please. Can you please do that?
Yes, I'll be really quick.
So I can get a position where you can hear me. So the department determined the moral fitness violations were for misconduct, that you violated criminal law, employed as a corrections officer, and admitted to driving while under the influence of alcohol. That your conduct threatened harm to people and property and violated the Criminal Justice Code of Ethics. That you violated several traffic while employed as a corrections officer, which threatened harm to people and property. The totality of which, along with DUI and reckless driving, evidenced a disregard for the traffic laws of both the state of Oregon and Washington. As a corrections officer, Mr. White was responsible for holding adult custody accountable related to rules and laws. Corrections officers are expected to provide an example of behavior that aligns with sound judgment and rule-abiding behavior. Were you able to hear that?
Yes, ma'am.
All right. Are you prepared to provide your statement?
I'd like to remind him that he has 5 minutes. I don't think he's been informed of that.
Mr. White, you know you have a 5-minute time period.
Yes, ma'am.
And we won't have any questions or any question period time. So I want to make sure that you're aware of that too, Mr. White. It's just your statements.
Okay.
Thank you.
And I may give you a 1-minute warning. So you know where you are, okay?
Okay.
All right, you can begin.
Okay, so to begin with, I actually do have documentation, and Ms. Lavario, I gave you all these documentations for the failure to give info for A, where I was the victim of the accident. I actually my collarbone was broken in 3 spots. I don't know if you can see the scar here. If you can't, here's the bracket that was holding it in place. I was the victim of that accident. It was dismissed with prejudice. Concerning with the DUI arrest in 2018, I also have documentation that I did call DPSST and I did report this. When I discussed this with the old business agent, Roger Ware, I informed him, I was told by someone at DPSST that unless this DUI is a conviction, I do not have to self-report. If I'm still going to fight it, keep them updated. That's what I was told by your people at DPSST. So I did self-report that back in 2018. Regarding that DUI, yes, I did. I did it. I completed all sanctions that were imposed upon me by the court of Tri-Cities, Benton County. All fines, classes, that was all done as soon as possible. So as far as the failure to give info or aid, again, I was the victim in that one. I'm not sure what else to tell you on that. think there was another one from the other meeting about speeding on a motorcycle. During that time frame, I was not employed by the department. I'm not sure why that was being brought up. I was exonerated of that, or not exonerated. I was pulled over. You know, I got a ticket for that, $1,100 ticket from that. Hold on. Getting the connection notification. I received a traffic violation for that. Speeding for the motorcycle. Paid it off. I did everything that was mandated of me. Yeah, I'm not sure what else to tell you. I mean, everything that's there as far as refusing overtime. I came in the day before. I had a known history of doing overtime at TRCI. And also concerning the arbitration for the wrongful termination, the arbitrator also stated in his notes, I was fired for reasons not stated. There was documentation of management at TRCI that they were being dishonest, intentionally dishonest with their paperwork. And that's it.
Thank you.
Thank you, Mr. White. We will forward, ask for consensus of the committee to adopt the record, or return the case for additional information. So committee members just want to adopt the record or return it to staff. So we're good to adopt. Confirm that the consensus to adopt the record is approved. Are there any objections? Stating none. We'll move forward and we'll open the case for discussion. Remember to state your name and identify any aggravating or mitigating factors.
For the record, more of a clarification. We did review this case last time. In the minutes, there's several identified aggravating mitigating factors. Can we just reaffirm those?
We'll need to repeat them on the record and then go from there.
Good.
Since we're kind of starting in some respects.
Gotcha.
I blame you for the record. Now I'm gonna ask for clarifying. So are we saying that the aggravating factors that were identified previously we're just gonna completely redo that?
We just need to repeat them on record now.
Okay.
If that's what people still think.
Thank you.
For the record, I can read them.
Please do.
Thank you. The aggravating factors were the two criminal convictions show a pattern of behavior with a significant time between the two incidents. There was dishonesty in the 2014 reckless driving incident. I apologize, I'm reading the wrong. Aggravating factors: White's numerous traffic violations after his conviction showed disregard for the law. His mitigation letter did not include any responsibility for his actions, and he blamed others. White has taken no accountability for his traffic law violations, which continued into 2024. White has exhibited a pattern of disregard for the laws of the state of Oregon, the state of Washington. Driving 102 miles per hour on a motorcycle is putting the public in significant jeopardy with disregard for human life. The arbitrator's opinion relating to reinstating White's employment relied on procedural issues, and the arbitrator affirmed that White engaged in misconduct. White's criminal conduct is aggravating. White did not report his criminal conduct to DPSST or the Department of Correction appropriately. White's failure to report his criminal conduct could be considered dishonest, but not a moral fitness violation as outlined in OAR. The mitigating factors, the committee did not identify any mitigating factors.
Thank you.
Nick Honor. Oh, go ahead, Josh. Josh Aldridge for the record. I know we mentioned the lack of accountability in the mitigation letter. I want to add to that was my observation today of Mr. White's statement. I didn't hear any accountability. The closest thing I heard was a "yes, I did it" comment. Instead, I heard a lot of blame pointed in the direction of other people involved with the situations.
Thank you.
And Josh, just for clarity, that was an aggravating factor.
Yes, aggravating factor. Thank you.
Nick Hunter, for the record, aggravating factor. I want to go back to that piece on dishonesty. And actually go to a comment made by the arbitrator. The arbitrator actually, in his report, made the comment, through the events leading to this hearing, referring to Mr. White, an impulse to tell a different story at different stages of this matter. I believe the aggravating factor here is dishonesty. And so we can call it, what the arbitrator did, which was storytelling, but specific to the incident, on November 9th and November 10th. And then what, the excuse that he provided during the internal investigation involved dry heaving, nausea that he didn't have medication for. The excuse that he provided to the arbitrator, during the formal arbitration, was that he had experienced his stepfather losing his job, and his stepfather then having suicidal thoughts. And this is why he couldn't go to work on that day. So whether we call it storytelling, whether we call it omissions, the bottom line is there is dishonesty in the statements made by Mr. White.
Thank you, Sheriff Hunter. Any other aggravating or mitigating factors by anyone?
I have one point of clarification. This is Maria Atwood for the record. When we were reading the previously noted aggravating factors, one of them that was discussed last time was that Mr. White had not notified DPSST of these issues. Today, however, during his verbal mitigation, he indicates that he did. So I want to make sure that the committee members are still wishing to adopt their previous aggravated factor of the belief that he did not notify, or if there's any discussion or change of that factor in particular.
Nick, for the record, I think that would be a clarification that would need to come from DPS S&T, because the way that Mr. White is sharing it is that he did do something. The question is whether what he did, was that procedurally correct within procedurally stated timelines? So I think that is a question for DPSST to answer.
So
I
that may be a
can
question
provide
for you,
some
Jennifer, if you have a clarification.
information that I have, having received this case after I came on, so there were other people involved, is that Mr. White did provide us information about the most current charge and conviction for reckless driving. There was a prior conviction, or not conviction, there was a prior criminal action that we did not have any information about. Therefore, we made that finding. So in one case, yes. In the prior case, no.
Nick, for the record, Jennifer, you're referring to the prior conviction that then was subsequently dismissed after the year of probation.
The failure to provide care.
Correct.
Yes.
So it was subsequently dismissed, but it was a conviction originally.
I would have to see whether we would internally call that through our rules a conviction or just a criminal disposition. I believe it's under Oregon Administrative Rule definitions of criminal disposition.
Okay.
Yeah.
Thank you for clarity.
Yes, thank you, everybody. Any other comments? Information? Want to go ahead and repeat the aggravating and mitigating
Sure.
factors for us?
I will just read them back from the minutes, if that's okay.
Yep.
And then the additional comments I will.
Perfect. Thank you, Jennifer.
We do not have in either today's case or when we heard the case last time, any mitigating factors. We do have aggravating factors. White's numerous traffic violations after his conviction shows a disregard for the law. White's mitigation letter did not include any responsibility for his actions. White blamed others. White has taken no accountability for his traffic law violations, which continued into 2024. White has exhibited a pattern of disregard for the laws of the state of Oregon and the state of Washington. Driving 102 miles per hour on a motorcycle is putting the public in significant jeopardy with disregard for human life. The arbitrator's opinion related to reinstating White's employment relied on procedural issues. The arbitrator affirmed that White engaged in misconduct. White's criminal conduct is aggravating. White did not report his criminal conduct to DPSST or ODOC appropriately, as we clarified today. White's failure to report the criminal conduct could be considered dishonest, but not a moral fitness violation as outlined in Oregon Administrative Rule. In addition to that, what I heard today was the verbal statement that he provided. There was a continuation of no accountability and blaming during that statement. That White's dishonesty in his statements in the investigation and in the arbitration were dishonest. One might call them stories or excuses or omissions. I captured that correctly.
That's everything. So, everybody has consensus that she identified them correctly.
Yes.
Okay. So we will now, open the discussion whether we're gonna affirm, modify, or negate, the staff report. So I believe now we need to have a motion for that.
So Nick Hunter for the record, and Kathy, you can help me here, or Marie, you can help me. What I would like to do is make a motion to amend the staff report to include dishonesty as well as the misconduct that is previously stated. And I would like to include dishonesty, as I stated in the aggravating factors. Even the arbitrator had an issue with Mr. White's storytelling. And so if you look at the progression of the entire case file that we read, we saw multiple explanations for his actions. And I do believe that those multiple explanations, we can say somewhere in the middle lies the truth. The problem is the truth was not stated from the beginning to the end, which would be a pattern then, which would support the dishonesty as being included in the staff report.
Okay. So Marie Atwood, for the record, I think it procedurally might work too. So are you making one motion to affirm the existing allegations, another motion to modify by adding an additional allegation?
So moved.
Okay.
I will make that motion.
Okay.
Yes.
So the motion would be to affirm, and then modify.
Affirm on the misconduct and modify by including dishonesty.
Okay, thank you.
Ted Langley for the record, I'd second.
Thank you. So we go ahead and take a vote.
Right, we are voting on a motion to affirm the moral fitness violations presented and to modify to include dishonesty. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Vasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so the next will be to decide what action or no action to be taken. So we'll call for a motion for what anybody recommends. for-
Ted Langley for the record. I make a motion that the board take action.
Artie Bone for the record, I second.
We'll have a vote whether to take action in this case.
Right, we are voting on a motion to take action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Vasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, since the motion passed to take action, now we need to determine what's that action. Maybe this is a dishonesty and a misconduct. For the dishonesty, it is potentially a lifetime ineligibility period. So if anybody has a motion for that.
Nick Hunter, for the record, I would make a motion for an ineligibility period of 5 years, based on the staff report identification of misconduct, the supporting statements that have been made today into the record supporting that misconduct, as well as the addition of dishonesty into the record as well, and the statements made supporting the dishonesty discovered throughout the case file. With all of that being entered into the record, I would suggest or make a motion for an eligibility period of 5 years.
Okay, thank you.
Josh Elder Johnson.
Okay, so the motion is to have an eligibility period of 5 years. We will take a vote on that.
Mike Hartford, for the record, just quickly, it appears last time we recommended, we even without the dishonesty allegation that you recommended 10 years ineligibility. So just putting it out there that previously we recommended 10 years. We're adding a dishonesty component to this, and the recommendation is now 5 years.
Right.
So
So that is correct. And so then I think that either we have to vote on this. And then if it doesn't pass, then we can have another motion. I do believe that's correct. Correct? Okay.
All right, we are voting on a motion for a 5-year ineligibility period. Vice Chair Cameron.
Nay.
Committee Member Aldrich.
Nay.
Committee Member Bourne.
Nay.
Committee Member Bowden.
Nay.
Committee Member Fasco.
Nay.
Committee Member Frost.
Nay.
Committee Member Hartford.
Nay.
Committee Member Hunter.
Nay.
Committee Member Langley.
Nay.
Committee Member Mays.
Nay.
Committee Member Tabor.
Nay.
Motion failed.
Okay, so that motion failed. Is there any other motion?
Mark Bone, for the record, what is our time frame for these? Like, I know dishonesty is up to lifetime, but I mean, I've seen lifetime for less here. And we have a blatant disregard for all criminal activity. I mean, 8 violations in 8 years. Safety and security of the people that we're supposed to protect and honesty.
Right, so just I'll repeat. So issues of authority or misconduct is 3 to 10 years. And then dishonesty, misconduct that is discriminatory is 3 years to lifetime. So certainly you can make a motion.
Yeah,
What you
so
think is
the totality, because you have 2 different moral fitnesses, is 3 to lifetime is within your range. Okay, thank you. Appreciate that.
Mike Hartford, for the record, I recommend a 10-year ineligibility period consistent with our previous recommendation.
John Frost, for the record, I'll second that.
Okay, we'll take a vote for a 10-year ineligibility period.
We are voting on a motion for a 10-year ineligibility period. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Nay.
Committee Member Fasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Nay.
Motion passed.
Okay, so motion passed for a 10-year ineligibility period for Mr. White.
I'm sure you can excuse Mr. White.
Mr. White, yes. You can certainly stay on. It's a public meeting, or you can choose to leave, and we thank you for your testimony. We will move next to, case number 5, Catherine Mood. Jennifer?
Jennifer Lavario for the record. This next case before you is that of Catherine Mood. The department opened a professional standards review after receiving information from Catherine Mood that she was criminally cited on March 23, 2022 for driving under the influence of intoxicants, reckless driving, failure to perform the duties of a driver, and criminal mischief in Marion County, Oregon. Ms. Mood's employer at the time, the Marion County Sheriff's Office, conducted an investigation into the March 23 incident and imposed an economic sanction that included Ms. Mood signing a last chance agreement for a 3-year period. The last chance agreement was signed on November 25th of 2022. On October 17th of 2023, Ms. Wood was cited a second time for driving under the influence of intoxicants and reckless driving in Marion County. On October 18 of 2023, Ms. Mood was placed on administrative leave by the Marion County Sheriff's Office and an investigation was initiated. On January 12th of 2024, Ms. Mood resigned from the Marion County Sheriff's Office pursuant to a separation agreement and release, rendering their internal investigation suspended. On October 1st of 2024, Ms. Mood pled guilty to the driving under the influence and reckless driving charges stemming from the October 17th incident. The department's review determined that Ms. Mood did violate the board's moral fitness standards for dishonesty and misconduct. Dishonesty. Ms. Mood was intentionally deceptive during her criminal investigation on March 23, 2022 by fleeing the scene of the crash she caused while driving under the influence of intoxicants. Ms. Wood attempted to hide behind a tree from law enforcement and denied more than once that she had been drinking. Ms. Mood's blood alcohol content for this incident was 0.24%. Ms. Mood was intentionally deceptive during the criminal investigation on October 17th of 2023 by stating she had not been drinking but had consumed cough medicine with codeine. Ms. Mood's blood alcohol content for this incident was 0.13%. Misconduct. Ms. Wood violated criminal law by committing 2 separate offenses of driving under the influence and reckless driving, and then a failure to perform the duties of a driver, property damage. Criminal mischief as well, excuse me. Ms. Mood harmed property when she crashed into a PGE power pole, causing a power outage in Kaiser, including that of the Kaiser Police Department. The estimated damage in this crash was $30,000. Ms. Mood threatened harm to people and property for driving under the influence of intoxicants in both cases, which were within a year of each other. Ms. Mood harmed the efficient operations of the Kaiser Police Department when she hit the power pole, leading to a power outage at the police department. Ms. Mood harmed the efficient operations of the Kaiser Police Department when during one of the criminal investigations, she removed her driver's license from a counter in the police department and placed it in her pocket. The arresting officer determined this had happened only after seeing Ms. Mood on video. On video surveillance. Ms. Mood's conduct impeded the arresting officer's ability to process her arrest efficiently. Ms. Mood harmed her employing agency by damaging the public's trust in the integrity of the police profession. Vice Chair Cameron.
Thank you. So we just need to.
Madam Chair,
I'm
before
sorry.
we get started, I just want to state for the record, a conflict of interest. I am the one I accepted Ms. Mood's resignation as a sheriff. I don't know if that means I need to recuse myself from it. I just wanted to state the conflict of interest.
Captain McAlpin, no, you don't, just stating it, and if you feel that you can objective vote, and you're free to continue to vote. If there's not the conflict is noted. Thank you.
So first we'll go into, if we have a consensus to adopt, the record, as stated by Jennifer. Is everybody good with that? Any discussion? Oh,
Vice Chair Cameron, I just want to correct something I said in my opening
okay.
statement.
Yes, please do.
My last line was, that she damaged the public's trust and integrity of the police profession. We're talking about the corrections profession here.
Okay.
Thank you.
Okay, yes, thank you. Also, I saw that, member, Langley has left. Do we still have a quorum?
We do.
Okay. Confirm we are, have a consensus to adopt, the staff record. Now we will open it up for discussion, for any aggravating and mitigating factors, and just remember, to state your name for the record.
Josh Aldridge, for the record, aggravating circumstance is the multiple arrests in a short period of time. Additional aggravating circumstance is that during both of those incidents, Ms. Mood was deceptive and evasive during the arrest proceedings.
Thank you.
Marty Bowden, for the record. Another aggravating factor was that she actually fled the scene of her accident and tried to hide him from the police.
You?
Lori Frosco, for the record, aggravating factor is dishonesty at the time of offense and no accountability for her actions.
Thank you. Jennifer Cameron, for the record, one thing that stood out was she was given a chance, to make things right, and she did not. So I find that as an aggravating factor. Any other discussion? Anyone online have anything?
Josh Aldridge, for the record, sorry.
Nope, you're good.
I believe the second offense was while Ms. Mood was on diversion for the first offense.
Mhm.
And so I believe that's an aggravating factor. Additionally, one more piece is surrounds her interfering with the investigation by taking her identification while the arresting officer was trying to process that arrest. Another aggravating factor.
Thank you. Any other aggravating or mitigating factors by anyone? Okay, if we can repeat those.
Thank you. Jennifer Labaria, for the record. I heard no mitigating factors from the committee. The aggravating factors were that there were multiple arrests in a short period of time. During both, she was deceptive and evasive, and I heard dishonest as well. She fled the scene of the accident. She took no accountability for her actions. Even after being given a chance, she did not. She went ahead and did. Let me restate that. After being given a chance, she didn't take that chance. Her second offense was while she was on diversion. And by interfering with the arrest, and by taking the ID off the counter, that impeded the investigation.
Kind of for the record, I would add an aggravating factor of a pattern of dishonesty from the first arrest through the processing, the intentional dishonesty of taking the ID off the counter, and then the continued dishonesty with the second arrest.
Okay, thank you. Do we have a consensus that those factors were as stated by everybody? Okay. Yep, okay, let's move on. Now we can affirm, modify, or negate the staff report. So we can call for a motion on that.
Josh Aldridge, for the record, I would move we affirm the staff report showing violations of misconduct and dishonesty.
Second.
Okay, so we have a motion to affirm the staff report as recommended for misconduct and dishonesty. And you think that's it?
All right. We are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Board.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford. Committee Member Hunter.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Now we need to have a motion whether we're going to take action or no action.
Marty Bowden, for the record, I motion we take action.
Thank you.
Lori Frosco, second.
There's a motion to take action in this case.
We are voting on a motion to take action. Vice Chair Cameron,
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne,
Aye.
Committee Member Bowden. Committee Member Pasco.
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter,
Aye.
Committee Member Mays,
Aye.
and Committee Member Tabor.
Aye.
Motion passed.
Okay, so we have a motion to take actions past the next step we need to take is have a motion for the recommendation of an ineligibility period since there is dishonesty and misconduct. It's 3 years to lifetime. And when you make your motion, please specify your reasons why and the timeline you're recommending.
For the record, I'm recommending a lifetime ineligibility period, pattern of dishonesty. She can't be trusted in law enforcement going forward, I believe. Ongoing unaddressed alcohol issues make her unfit to be a officer in Oregon.
Thank you.
Josh Aldrich for the record, I'll second.
Okay, so we have a motion for a lifetime ineligibility. I don't know why I have a hard time with that word, ineligibility period. So can we have a vote?
We are voting on a motion for a lifetime ineligibility period. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Vasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford. Committee Member Hunter.
Aye.
Committee Member Mays
Aye.
and Committee Member Tabor.
Aye.
Motion passed.
Okay, move on to agenda item number 6, which is Chance Oxman. And I think Jennifer's presenting that this as well.
Thank you, Vice Chair Cameron. Jennifer Lavario for the record. The next case before you is that of Chance Oxnam. The department opened a professional standards review after receiving information that Chance Oxman was cited for driving under the influence and transporting a minor while under the influence on August 18 of 2023 in Meridian, Idaho. On October 3rd of 2023, Mr. Oxnam entered into a diversion agreement for the DUI and the transporting a minor while under the influence charge was dismissed. On October 17th of 2024, the DUI was dismissed due to Mr. Oxnam's successful completion of the conditions of his diversion program. Mr. Oxnam is currently employed with the Department of Corrections, Snake River Correctional Institution. The department's review determined Mr. Oxnam did violate the board's moral fitness standards for misconduct. Mr. Oxnam violated criminal law when he was cited and charged with the DUI and transporting a minor while under the influence in Idaho. Mr. Oxnam threatened to harm his minor son, an adult passenger, and other people and property when he drove his vehicle under the influence of alcohol and over the legal limit. Vice Chair Cameron.
Thank you, Jennifer. So we need is there a consensus of the committee to adopt the record, the staff record as presented by Jennifer? It looks like I have a lot of thumbs up. So we have adopted the record through consensus. Next we'll open for discussion for the aggravating and mitigating factors.
Josh Aldrich for the record, aggravating factors. First, that other individuals, including minor children, were placed at risk because of this decision to drive while under the influence. And then second aggravating factor is that at the time of the arrest, at least, Mr. Oxnam was not forthright about his drinking that day.
Is that it?
That's it for now.
Thanks.
It kind
Sean.
of,
Go ahead, Joe.
John Tabor for the record, mitigating factor. He completed his diversion program as required.
Thank you.
Nick Hunter for the record, mitigating factor. Mr. Oxum did provide a mitigation letter where he appears to have taken accountability for the action, also highlighting that he does not have any internal disciplinary measures or anything else that's ever been taken against him.
Thank you. Anything else? Online? Can we repeat those factors, please?
Yes, thank you, Chair. Jennifer Lavario for the record. I have in this case for mitigating that Mr. Oxnam completed his diversion. He provided in his mitigation letter some accountability for his actions and that there are no other non-disciplinary actions in his career with the DOC. Aggravating, other people, including a minor, were put in harm's way that day when he drove under the influence. And that at the beginning of the arrest, he was not forthright with the officer about his drinking.
Thank you, Jennifer. Then we just need to make sure there's a consensus regarding the identified factors that Jennifer has presented. Anybody online have any comments? Okay. So there's a consensus regarding the mitigating and aggravating factors. So the next, we need to call for a motion to either affirm, modify, or negate the staff report as indicated.
Nick Hunter for the record, I'll make the motion that we accept the staff report as prepared.
Thank you.
Mark Boren, I'll second.
Okay, we have a motion to accept the staff report as prepared.
Are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Fresco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays
Aye.
and Committee Member Tabor.
Aye.
Motion passed.
Thank you. The next motion will need to determine if we want to take action or no action. I'll open it.
Josh Aldrich for the record, I would move that the committee recommend to take no action, and I would base that on the fact that he's taken accountability for his actions, he's completed diversion. This is just an opportunity to give him an opportunity.
Thank you.
Nick Hunter for the record, I'll second that.
Thank you. So there is a motion to take no action in the case of Chance Oxnam. Member, please.
We are voting on a motion to take no action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Fresco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays
Aye.
and Committee Member Tabor.
Aye.
Motion passed.
Thank you. Next, we'll move on to the case of Brian. I don't want to butcher the names. Sharbach. Sharbach. Thank you. I appreciate that.
I did work with this person, Lori Frostman, brother, I did work with this person during his employment. I did some training with them and, I wasn't involved in any part of it.
Okay, thank you for letting us know. Once again, Jennifer, you are up.
Thank you, Vice Chair Cameron. Jennifer Lavario for the record. The next case before you is that of Brian Sharbach. The department opened a professional standards review after receiving information that Brian Sharbach had resigned from the Department of Corrections while under investigation into allegations of misconduct related to Mr. Scharbach's accessing confidential information about another Department of Corrections staff member and then sharing it with others without consent. The department's review determined that Mr. Scharbach did violate the board's moral fitness standards for misuse of authority and misconduct. Misuse of authority, Mr. Scharbach intentionally misused his authority when he used it to access the confidential officer in charge field training evaluation program files of a fellow officer without their or DOC's permission. This access was for Mr. Scharbach's personal gain and did not have any business purpose. Mr. Scharbach intentionally misused his authority to place a personal thumb drive with admittedly pirated movies on a DOC computer in order to view these movies while on duty for personal gain and entertainment. Under misconduct, Mr. Scharbach admittedly used his access to confidential information to harm a fellow officer's reputation by exposing negative information about them to other officers. This conduct did threaten harm to the fellow officer's reputation. Mr. Scharbach's conduct harmed the safety and security of the DOC's Department of Corrections confidential information systems when he accessed unauthorized information and by downloading content from a personal thumb drive, exposing the Department of Corrections to potential corruption of files and threatening the efficient operations of the agency. The totality of his conduct also harmed the integrity of the Department of Corrections information systems and violated the Law Enforcement Code of Ethics. Mr. Scharbach threatened physical harm to staff who he believed turned him in for this conduct. He did so in a phone conversation with the officer in charge. Chair Cameron.
Thank you. So we do have a consensus to adopt the record, the staff record as stated. A return for any information. Everybody, okay, we're in consensus to adopt staff record. Now we can open it up for discussion on aggravating or mitigating factors regarding this case.
Ed Langley for the record. One aggravating factor that I found was the downloading of the movies onto a thumb drive. Whether or not he got charged with a crime, that's theft. It was copyrighted material. The other aggravating factor I wanted to point out was the threat to harm another staff member isn't just a threat. That's him voicing that he'd be willing to commit yet another crime of assault for. So I found both of those to be aggravating factors in the case.
Thank you.
John Tabor for the record. An aggravating factor is the amount of information provided to staff regarding the confidentiality of our electronic information is far and away enough for him to have understood that what he did was outside the bounds of our own rules and policies.
Thank you.
The counter for the record aggravating factor. He was well aware of that and made the statement out of his own mouth that he admitted to not following code of ethics. Another aggravating factor using his own statements. I mean, I'm not an OIC, so no one asked if you're supposed to be referencing or going into these files. A blatant disregard for policies and procedures, as stated in his own words throughout the internal investigation, which is bordering on being sociopathic, amongst other things.
Thank you. Jennifer Cameron for the record, an aggravating factor for me, and I'm kind of going off what Member Langley stated, the threats to the others who he thought had kind of narked on him. Not to mention it's potential threatening to commit assault, but just the intimidation and kind of in some ways attempting to interfere with the investigation or threaten people so that maybe they don't give the correct information or whatever. I just find that not okay.
Barbara Wood for the record, aggravating factor also to go off, it's not me as well. But the jump drive or the thumb drive, he admits to taking it to work. He also admits to watching movies while he's at work, which be considered theft of time and not doing what he's supposed to be doing, which is watching the inmates, I would assume. So
They got it for the record aggravating factor, and it goes along with where Captain Langley was at. But I think had this been sent out, there's also, I'm not sure you get to official misconduct 1, but I think you could have done an official misconduct 2 based on the information that he was disseminating and how he was accessing and disseminating that information. So I think along with Captain Langley, there are multiple criminal charges that exist in the midst of this investigation.
Thank you. Anything else from the members? Okay. Want to repeat all that?
Vice Chair Cameron, that's Jennifer Lavario for the record. I did not hear any mitigating factors from the committee. The aggravating factors that I identified through your discussion are that Mr. Sharbach downloaded movies, which he admittedly pirated, which is theft. His threat to harm of those who were turning him in wasn't just a threat, but potentially an admission of another crime, potentially assault. The amount of information provided to staff about confidentiality at the Department of Corrections was clearly enough for Mr. Sharbach to know that he was breaking the rules. Mr. Sharbach was well aware and admitted to not following the code of ethics. There was a blatant disregard for the policies and procedures of the department in his own words. His threats to others were intimidating and potentially interfering with the internal investigation. He admitted to taking the thumb drive and not only watching movies while on duty, but placing the thumb drive in the DOC computer, which could be considered a theft of time. The totality of the things that Mr. Sharbach, the conduct here in Mr. Sharbach's case, could have led to an official misconduct charge. And I believe that's all.
Thank you.
Nick, for the record, on an aggravating factor, I am sorry, I'm reviewing and I'm looking at the staff report and the staff report not addressing dishonesty. I think dishonesty is a factor that should be considered in this. Although when he first discovered the file, he sent something to, it's correct on the file term, but the assistant security or something of security. He sent it to somebody to say, hey, I got access to this file with screenshots. But then he proceeded to just share that information and use that information, which has dishonesty built into that. It is omission. He is omitting the fact that he is calling on these other people, showing this information and doing those things, which he should know to be wrong based on that code of ethics. So I would add that as an aggravating factor, and we can address that in the staff report.
Thank you.
Headlining for the record, I did want to clarify one thing. When I brought up the threat on the staff and potentially him showing willingness to commit another crime, if I misspoke and said he was confessing or admitting to committing the crime, that's not what I intended. I was just intending to say that he showed willingness to do that. That's all.
Thank you for clarifying. Okay, is there consensus to the aggravating factors as indicated? Yes. Any objections online or not seeing any? Next, we will call for a motion to either affirm, modify, or negate the options of the moral fitness findings identified in the staff report. Is that correct? Yes. It is right. I know, I'm getting through this. What can I say?
Nick Hunter for the
I'm not
record.
perfect.
I would make a motion this time that we modify the findings in the staff report, accepting the findings of misconduct
and additionally adding dishonesty based on what was just identified in the aggravating factors of knowing what he was doing and omitting all of that is a form of dishonesty that I think is supported by what is contained in the case file.
Thank you. I don't know if I could repeat that.
You're not the first one to say that to me.
Josh Eldridge, I was second.
That's different.
Yes.
As stated. Sure.
Marie, I would one point of clarification. So in the motion as it stands, it was a motion to accept the allegations of misconduct and to add a finding of dishonesty, but there was also a finding by our staff for misuse of authority. So what, if anything, would the committee like to do with that?
Would amend my motion and add misuse of authority as accepting that before modifying to add dishonesty.
Motion to amend, the motion to modify.
Yeah, I'm gonna make a
And
motion
accept.
to amend my motion, accepting the original findings in the staff report of misconduct and misuse of authority. And then for the reasons stipulated and stated, to add dishonesty.
Josh Eldridge, I would second the amended motion by Sheriff Hunter.
Okay, so I appreciate you making it difficult for me. So I'm just gonna throw out there, what we have on the table then is to accept the staff report as written and then modify to add the dishonesty element. That's simple. Okay, go for it.
We are voting on a motion to affirm the moral fitness violations presented and also to modify to include dishonesty. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Vasco.
Aye.
Committee Member Frost.
Aye.
Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. The next step will be to determine if we plan to take action or no action. In this case. Jennifer Cameron, for the record, I recommend we take action.
For the record, I second.
Thank you. So the motion to take action, in this case,
Right, we are voting on a motion to take action. Vice Chair Cameron.
aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Vasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so there is, the motion passed to take action, so our next step will to determine what action that might be and what eligibility period will recommend it. Since we added dishonesty, we have dishonesty, misuse of authority, and misconduct, it would be anywhere from 3 years to a lifetime.
I think for the record, I'll make a motion to support lifetime ineligibility. You have dishonesty, misuse of authority, and misconduct. That misconduct has stated and discussed potentially could have been criminally investigated and potentially could have been criminally charged. But I think there is a pattern of behavior here that is way outside the ethical bounds of what we expect of our public safety professionals here in the state of Oregon.
Thank you.
Mike Arthur, for the record, that's second.
So we have a motion for a lifetime ineligibility period based on dishonesty, misuse of authority, and misconduct. Okay,
We are voting on a motion for lifetime ineligibility period. Vice Chair Cameron.
aye.
Committee Member Aldrich.
Aye.
Committee Member Warren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Fresco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, see if they need a break or anything, just checking. We've been here a little while, just so I throw that out there. I don't know if we. Yeah, oh, yes, because that's right, she has.
Yeah, but if
She have to go,
people
but
need a
if,
break,
I mean, it's 11:30 and I figured we have 2 cases plus a little bit more. We've been here for an hour and a half, so if anybody needs something really quick, or hopefully we can get through quickly, I'm just. You good? Okay, so we'll move forward. Just throwing that out there. I like to.
We've had a couple of online requests for a break to take 5.
Request take 5, just throwing that out there in case anybody needs it, so they may need 5. We're good.
Yes.
We're moving forward.
Take 5.
Hang tight for 5 minutes. Thank you. Sorry. I just felt like people just needed to